Hello, everyone, and welcome. I hope you've been enjoying World Water Week so far. As attendees are signing in, I'd like to briefly cover some logistics for today's session. All attendees are muted automatically upon entry. Please double check this on your end and ensure you're muted during the keynote and whenever you're not speaking. This will help minimize feedback on our end and ensure that everyone can hear the speakers. If you want to view the live transcript, turn it on using the closed captioning button at the bottom of your Zoom screen in the menu tab. This is an interactive session, and we invite you to turn your videos on, especially during breakout groups. If you haven't yet downloaded Zoom, please do so now. You will need this in order to participate in the breakout sessions. Finally, feel free to put questions and comments in the World Water Week Pathable platform chat throughout today's session. You're also welcome to say hello and introduce yourselves and the location you're calling in from as you sign in. Today's session is part 3 of 3 in a seminar series on information, governance, and justice for climate resilience. This seminar would not be possible without our fabulous co-conveners. So I'd like to give a big thank you to these organizations. As you're signing in, we're wondering how many of you have been able to join us for parts 1 and 2 of this series. If you were there, what did you think? Please feel free to share some feedback in the chat. For those of you who couldn't tune in, you can access these sessions on the World Water Week platform. In session 1, we heard stories from across the globe on using climate information services and participatory governance approaches for building climate resilience. In session 2, we spoke with experts on how to center climate information, community power, Indigenous leadership, youth activism, and justice in efforts to secure our water future amidst a changing climate. That session was moderated by Jan van de Vennis, who was an advisor in the recent court case against Shell in the Netherlands, which we'll talk a little bit about today. This brings us to today's session on making the case. Can climate and water justice be achieved through the courts? To explore this topic, we'll first hear a keynote on trends and existing litigations around the world. We'll then have some time for questions, followed by a few live polls. Then we'll break out into small groups for discussion. Finally, we'll return to this main room for a moderated reflection and insights, and then closing remarks. Today's speakers include Dr. Jenny Gronwall, advisor on water policy and rights at SIWI. Jenny is also SIWI's focal point on the human rights-based approach and has worked for many years on governance for groundwater, particularly in India and sub-Saharan Africa. We're also joined by Dr. Phil Graham, International Program Manager for Water and Climate at the Swedish Meteorological and Hydrological Institute. Phil specializes in water resources management, hydrology, hydrometeorological services, and climate science, with a particular focus on capacity development in Africa, Southeast Asia, and the Middle East. Both Jenny and Phil are also members of the Scientific Program Committee for World Water Week. And finally, it is my pleasure to introduce Professor Jonas Ebison, Director of the Stockholm Environmental Law and Policy Center at Stockholm University. Jonas's work focuses on the transboundary dimensions of environmental law, public participation, and access to justice and human rights. He is an expert in the growing field of climate lawsuits and litigations, several of which you'll hear about today. Please remember to submit your questions in the chat on the World Water Week platform throughout our session. And with that, I'd like to welcome our keynote, Professor Jonas Ebison.
Thank you very much, Katie. Thank you, Jenny, and thank you, Phil. It is a great pleasure to make this presentation about climate justice through climate lawsuits. in this final session of the seminar on information governance and justice for climate resilience. While I will focus on climate change lawsuits broadly, it is common that water issues are part of the case. And even in those cases where water is not at the core of the lawsuit, water is still somehow there. The outcome of the case does always matter for water. Now, climate change law in general addresses the different scales of climate change from global to local contexts. And the global context is reflected in the 1992 United Nations Convention, Framework Convention on Climate Change. It was adopted at the Rio Conference. This Framework Convention is the global legal platform, the global constitution, if you wish, for climate change governance, cooperation, and negotiations. To some extent, it also addresses justice and equity issues at the interstate level. While the Framework Convention was slightly made more concrete with the 1997 Kyoto Protocol and the 2015 Paris Agreement, they are more precise and they address justice and issues also. Nevertheless, they still remain rather abstract in defining what states are supposed to do to combat climate change and to adapt to it. The human rights dimension has been advocated in these global negotiations since the starting. Early on, small island states in the Pacific and elsewhere made the fundamental point that if climate science is correct, then these states will cease to exist within a century. Despite this urgent message, the human rights dimension has had a rather marginal role and been rather marginally addressed so far in the global climate change negotiations. But there are also regional and local contexts of climate change law and justice, not least with respect to security and adaptation. We heard as part of this seminar how important it is with rapid and adequate access to information to reduce harm, and other measures taken at the local level to reduce the effect of climate change are also important, and they engage climate justice. In parallel to the global negotiations, states and the European Union are taking legal measures to reduce CO2 emissions and to adapt to climate change. But the key point is, how do you make the talk into action, and how do you implement this legislation? There is a general frustration that all this takes too long time, and there is a legitimate urgency among, in particular, the youth. This affects certain regions, certain countries, certain groups, and certain classes unfairly and unproportionally compared to others. We have seen in the thousands of manifestations on the streets how this is engaging people, and now we see it in thousands of lawsuits around the world. And now in the courtroom, the human rights takes a more prominent role than they had done previously in the global negotiations. According to two databases, there have been about 1,800 lawsuits around the world in the last 30 years or so. The great majority of those have taken place in the United States of America, but there have been lawsuits in around 40 countries around the world, in all regions of the world. So I will start with give you a couple of presentations about some high-profile lawsuits, and then based on those, I will explain what are the key elements, who brings them, what is called for, and so on. We will discuss why they are relevant, and at the end, whether or not they indeed promote justice somehow. The first case, Ashkar Ligari versus the Federation of Pakistan, was brought in 2015 by a farmer in Pakistan who sued the federal state. He claimed that the government's inaction and delay in implementing the national climate policy violated fundamental constitutional rights to life and dignity. And the court agreed. In its ruling of 2015, the court was clear. The state's delay in implementing the climate framework violated citizens' rights to be protected. The court thus ordered the state and the responsible ministers to prepare a list of adaptation measures to be taken and to assign responsible staff to that end. It also established a particular climate change commission, which was later replaced by a standing committee on climate change. So this was one of the first high-profile cases that have been discussed worldwide. The second case is the Justicia y Otros contra la Presidencia de la República y Otros. It's a Colombian case where 25 children and youth sued the president and several governmental bodies through a tutela, which is a special Colombian remedy to protect constitutional rights. They asked the court to stop deforestation in the Amazon region, and climate change was one of several harmful effects raised in this case. In 2018, the Supreme Court was clear. The government's action had been ineffective, inter alia, to address climate change and to protect against infringements of fundamental legal guarantees. The court ruled in favor of the plaintiff. It ordered the states to take several measures to prevent deforestation and deal with climate change issues. We moved from Latin America to Europe, and what is maybe the most famous lawsuit so far, Urgenda Foundation versus the Netherlands. The Dutch foundation Urgenda sued the state of Netherlands for not taking measures required by Dutch civil law, the Dutch constitution, and the European Convention on Human Rights. It also invoked the Paris Agreement and other international and EU legal acts. And this case went all the way up to the Supreme Court, which in 2019 ruled in favor of Urgenda. It concluded that by not taking sufficient measures, the Netherlands had violated basic human rights, the right to life, and the right to respect to private and family life under the European Convention on Human Rights. And it ordered the state to reduce the total national emissions by 25%, which was what had been claimed by Urgenda, by 2020 compared to the 1990 levels. In another recent case in Europe, Oxfam, Notre Affaire à Tout, and all other environmental NGOs sued France and argued that the state had caused ecological and moral damage already to the plaintiffs by failing to take sufficient measures set out in French law to reduce emission of greenhouse gases. And in February, the court ruled in their favor. It concluded that France has caused already ecological damage due to climate change. France is responsible for this failure of achieving the objective set out in French law of reducing greenhouse gases. And the court ordered the state to prepare further information so that the court later could decide on appropriate measures to restore the damage or avoid further damage. So we see that the message is very clear. And I should say, of course, in these cases, but it is generally my conclusion when I look at how courts deal with these cases, that courts are not climate change deniers. They take climate change seriously and they confirm the science behind climate change. Now, these four cases were all addressed to states and about state responsibility. The fifth case, Milieu Defensie, Greenpeace and others versus Royal Dutch Shell, is a recent case where the defendant is the corporate group Royal Dutch Shell. It is a holding company of the corporate group consisting of some 1,100 subsidiaries in 160 states. It's yet only decided by the district court, but it's most likely to go to the Supreme Court. In this case, the court applied Dutch civil law and a provision which requires private entities to act with due care. It is a provision which it interpreted in light of international human rights law and the United Nations guiding principles on business and human rights, which sets out that business are also responsible to respect established human rights. The court ordered the Shell corporate group to take action throughout its organization worldwide in the 160 states, including the consumers of the products sold by Shell, to reduce its emissions of greenhouse gases by 45% in 2030 compared to 2019, which is a huge and comprehensive ruling. It's highly interesting and it raises a number of legal questions. Now, based on these 5 cases, what are they about? Well, we see that they clearly reflect a frustration about too slow climate change transformation among states and corporations. In a way, they also test the laws, either to be successful or to show that the existing laws are not sufficient and new laws and policies are needed. They pushed, and this I think is the most important point, they push for more effective enforcement and compliance with what already exists, whether it refers to mitigation and reduction of greenhouse gases, to adaptation measures, to reporting requirements and access to information. The point is that they are good. There are laws in place, but they are not sufficiently enforced or implemented. So what legal basis are there? If court rulings and lawsuits are supposed to enforce existing laws, which laws are we talking about? This is very national dependent. So, of course, in Colombia, in Pakistan, and in the Netherlands and France, they refer to different national laws, either new specific climate acts or existing legal principles or rules that they use in new context. It can be fundamental principles, constitutional provisions, due diligence standards in civil law, as we saw. They also, of course, refer to the international climate legal context with the Framework Convention, the Paris Agreement, etc. And not least, they also invoke human rights law. And for all the EU member states in Europe, the European Convention on Human Rights is a part of the law. And in most cases, like in the Netherlands, in Sweden, it has also a constitutional value. So then, are they relevant? Do they really matter, these lawsuits? If so, why do they do that? There are many reasons. First, while the global negotiations on climate change have been at a rather abstract and general level, the lawsuits make climate change and the abstract and complex context more concrete. They address the causality between causes, risks, and effects, and also innovatively apply existing rules on burden of proof and on causality. They highlight and allocate responsibility based on these conclusions. In the Dutch case, and also in other cases, the states often argue that it doesn't matter if we reduce our CO2 emissions, the Netherlands only represents 1%. Why shall we be responsible? And the court turned that down, saying, no, you are responsible to deal with your issues. You cannot just place it elsewhere. And the same with corporations. They accentuate human rights, as I just said, and they enforce existing laws of different characters. They also show shortcomings in legal and policy frameworks, and again, they address justice. If so, if we don't use justice just as a synonym for law, in which way can lawsuits contribute to justice in one way or the other? One reason is that they can address the situation of those that are disproportionately affected. It is one thing to agree on a global goal of 2% or a national goal of net emissions by 2040, 45, or 50. It's another matter on how to allocate that and how to distribute it among those concerned so that it's fair, it's legitimate, and it is equitable. That is something that a court ruling may address. The point with distributive effects. Who benefits? Who suffers? Does someone benefit from maintaining the level of CO2 emissions, or by putting extremely hard burdens on certain other groups? The lawsuits may ensure minimum social, economic, and environmental rights in different ways, ensuring that there are sufficient adaptation plans to also protect those that are worst off. They can ensure access to information and also participatory rights, that members of the public can voice their concern about climate change. As I just mentioned, they can enforce laws on climate change and human rights also. Not least, although it is not just a legal issue, these lawsuits can add to promote solidarity and sustainable development more generally. In the United Nations General Assembly's resolution on Agenda 2030 for Sustainable Development, key phrases are the solidarity of those that are worst affected, and the message is to leave no one behind and to reach the furthest behind first. Lawsuits may add to that. They cannot do it by themselves, but there are effective means to do that. And I haven't put on this list also, or maybe the previous one, another reason why climate change lawsuits are effective and useful is that they get media attention. This is a way to explain what climate justice and what climate change is about, because it refers to concrete cases. So I come now to my last slide, and I want to make some final points. I have addressed climate justice in courtrooms, but I want to make some clear points. Don't mix climate change lawsuits with climate change politics. The courtroom is not the parliament. The courtroom has another function than parliaments. Climate change lawsuits will not resolve the climate crisis by themselves. So we should not over-romanticize these lawsuits, but we should see them as important means for transformation to a climate-friendly future. Climate change policies, climate change law should be developed politically with broad public participation. Again, not in the courtroom. Having said that, and I hope that my presentation showed that, climate change lawsuits can help make climate laws and policies more effective and can indeed promote climate justice. So by that, thank you very much for your attention. I will be happy to discuss this further with Jenny now.
Thank you so much, Jonas. That was terrific. Very, very interesting indeed. I see that we don't have any questions from the audience yet, but I have some questions for you. I really appreciated how you were talking about justice and equity, human rights, leaving no one behind, and water issues as related and important in those climate change litigations that we see many more of. And indeed, I think we started to see this trend, as some say, since 2015. And you also mentioned that water is very often part of those litigations. And in a database of climate litigations, I found 188 cases that relate specifically to water. But in fact, as you mentioned, water in its different forms is referred to very often, and not least in this Shell case from May this year. Do you think that we are likely to see more of those litigations where water has a more or less prominent place?
Well, I think what you said, referring to about 180 cases of the 1800, I think that does not give a good picture, because Exactly. It would then mean that only 10%. What I pointed out at the outset is that I think almost every case that addresses climate change also relates to water. If you take the Urgenda case, yes. the Dutch case, the Urgenda, it addressed climate change as a global issue, but it focused on the responsibility of the Netherlands, which, as the Dutch government said, it only represents less than 1% of the global emissions. And the court held that the Netherlands is responsible. And it focused on the responsibility for the Netherlands to its own citizens, or people living in the Netherlands. Now, if you look at the Netherlands, it is one of the countries in the world which I think is has the biggest risks of damage if climate change is these effects get real. It is a country where a huge part of the country is actually under the sea level. So yeah. even though I mean, they refer to it, but it was not that the key focus was not on the canals or on these huge areas where the Netherlands have successfully been able to make land by taking out the water, but which is very can be very dangerous situation if you have more floods, if you have increased sea levels and so on. And I think this is reflected in most cases in one way or the other. The Colombian case was indeed about the Amazon River, so water is there, even though it also addressed deforestation for other reasons. The French case was broadly about climate change policy and its the schedule or trajectory that it has decided in the parliament, that it was not followed. But I think it's clear to France that water is there. So I think it is not, does not give a correct figure to
Exactly.
only to look at those where water is somehow the at the heading of the case, so to say.
Exactly. So indeed, for anyone who is interested in looking into those databases and find court cases that are relevant to water, you would probably need to actually go through all of them, the 1800 or so that we have. Thanks for that. You mentioned that cases are filed concerning reporting and access to information. And today, experts and prospective plaintiffs have more and more solid data to say how much climate change affects the likelihood and frequency of extreme events. And actually, just this Monday, a report from the World Weather Attribution Group was released, which firmly links the recent floodings in Germany and elsewhere in Europe this summer and the resulting damages, linking this with human-induced climate change. So what role does the advancements in science that feed into, for instance, high resolution computer models and the latest IPCC report, what role does this play with respect to court cases? How is data and information important to succeed in those litigations, would you say?
That is a very relevant point. When court decide cases, they essentially use two fields of information, so to say. One are the facts of the case, what has happened, what was the intention behind, and who acts and who is responsible. And the other one is, of course, to apply the legal framework to that. But having access to accurate data is fundamental. Now, of course, these successful cases, in these cases, the court took climate change seriously, as I said. But that is my general impression, although also in cases where the plaintiffs were not necessarily successful. There was a recent case in Norway where environmental organizations brought this government to the court because the government.
There were children involved then, wasn't it?
There were, in that case, well, there may have been some children, but there were the key actors were two NGOs. But they argued that the Norwegian government violated human rights, the same human rights essentially as in the Dutch case, but then based in the Norwegian constitution. They were not successful. This was about giving concessions to new oil drilling in the Arctic. Yeah. They were not successful. The court did not find Norway to violate human rights, but it's clear that the court took climate change seriously. It did not question climate change in any respect. So I think this of course is very important. I think we may find some cases where the court has not done that, but generally speaking, the courts take climate change seriously. But of course, the more information you have, in particular, if it shows the urgency, it also stressed to the court that this is something they have to deal with more quickly, that governments cannot refer to legislation to be taken 20 years ahead or 30 years ahead. There was also a recent case in Germany recently where NGOs had brought the government to the court arguing that their Climate Change Act, the act that is indeed intended to lead to reduced emissions of CO2 emissions, that it was unconstitutional because it has only set the trajectory until 2030 and then leaving to the government in 2030 with the parliament to decide on the rest of the pace. And the court said, no, given the German constitutional provision on future generations, this is not sufficient. You cannot put that in the future. And the data that you are referring to is important here too. We cannot wait. So, and then even though it will always be more or less impossible to link one specific emission of greenhouse gases to one specific harm, but lawyers and judges now, they are quite innovative in dealing with these things, also by using old legal concepts in new contexts.
Exactly. We saw that in the Shell case. That was very, very interesting. And generally, of course, those climate litigation cases, they are tough on the plaintiffs because of the difficulty in connecting damages in climate change impacts and specific companies. But in the Shell case, it's done in a smart way, talking about contributions and also actually dragging in the entire supply chain of the company in question. So thank you for that. I'm going to look at the passable chat now. I see we have one question regarding, will lawsuits be used to make corporations accountable for the past decades of misinformation on the science of climate change? So the misinformation, and that also, of course, relates to what we just discussed with regards to data. And so, and we have BP, for instance, that has known for the past at least 30 years, if not 50 years, about climate change being linked to its products. So will we see such law cases?
I think it's very likely. I mean, this is a bit like the tobacco cases that we saw 20, 30 years ago or so, where the tobacco industry had known for long the damaging effects of smoking. And now we see a bit the same thing here, that the oil industry, the car industry have known for long the effects. They have known for long ways to reduce the emissions, even when they continue to produce and deliver vehicles or fuel or whatever. So I think that could be part of cases. Then the question is, what does it end up to? Will it only, so to say, only mean that they have to pay fines or damages somehow to some public interest, or can this be used also, and I would think so, as a reason to require more quick delivery? If you look at the Shell case, I must say, when I saw that, I thought that could be really a game changer in the context of corporations. And there are some parts that could legitimately be discussed. I mean, whether a court in the Netherlands should be able to impose measures applicable to all the other 160 countries. I mean, really, you can make the case of environmental imperialism or whatever you want, but I mean, it addresses the urgency. And I think here, if you look at it from the company's perspective, to cut down by almost 50% its reducers of greenhouse gases, the main asset or the main function of these companies is to sell oil or fuel.
So it's basically a cease to desist.
And I would think here, but this is speculating, that the court also had in mind that this has been known for companies. I mean, we have had, I started to mention the 1992 conference where the framework convention was adopted. We have been doing this for 30 years, and still we see so little that has been achieved. Rather the contrary. Well, there's a lot of climate talk, but to a great extent, the development has gone in the wrong direction. And corporations, they can greenwash, and governments as well, of course. We still have a problem with that. This idea about net emission is also an issue that could be very seriously taken and stimulate and inspire for action. But it is also, it could also be used as a greenwashing phrase.
Definitely, that is what we see. I'm going to bring in another question from the chat. Are there examples or lawsuits that have involved insurance companies or issues related to insurance?
I know that there are. It's not that I can report on anyone, but the insurance companies, and that's also a very good point. I mean, the insurance companies, they are like the canary birds in the Irish mines that you used to say. They react early on. Before most other actors engage. They are concerned about this. And we see now, we have this discussion in Sweden and all over Europe now with increased risks for floods. The first to react to that are the insurance companies, because they will then charge more and they will develop new policies to that. So I don't have any case, but I would be very surprised if not quite a few of the 1,800 registered cases also engage insurance companies.
I would say so. And good that you point out that the insurance companies have been on this and been very much aware and tried to raise those flags for, I would say, more than 2 decades. So in short, they have been trying what they can from their horizon to really drive the change. And at the end of the day, of course, there's plenty of money involved here. The damages just in Germany are, we're seeing amounts that are impactful, really. And we have very recently in Sweden, we have Gävle with plenty of people who simply have to leave their homes. They cannot go back there. So the insurance companies are the ones that they turn to in the first instance, because no one else can help them, really.
One could have expected that the insurance companies have been a bit more, not aggressive, but a bit more action-oriented. But of course, they are competing with each other also. But I mean, I think that if they had, as you say, if they had been engaged in this for 20 years or so, one would have expected that they would have been maybe more of a key driver, or maybe show more new forward-looking approaches.
So okay, that's a call then to insurance companies to be even more proactive and push policymakers, push all of us, really. And of course, those of us who have insurances, we will see the tariffs go up, and we will understand that we need more fully covering insurance conditions for the future. So one last question, Jonas. Can you say something, you have alluded to it already, but can you say something on the democratic legitimacy of judicial lawmaking? That is, when judges create law as a result of courtroom verdicts.
This is a common critique against lawsuits, and there is an important point in that we should not see the court making the policies. They should apply the laws. That is the legitimate function. But we should also be aware that the laws look very differently. We have, like in the French case, there we had a rather clear Climate Change Act. It was not so difficult to see, did the measures taken by the government department, do they follow this trajectory of phasing out emissions? But when we speak about human rights law, for instance, it is not so clear. In Europe, the European Convention on Human Rights was adopted in 1950. There is not a mentioning of environment. There is not a mentioning, of course, of climate change. And this is how old frameworks, legal frameworks work. I mean, we have some constitutions that are 200 years old, and they have been used in cases about abortion, climate, new things that they didn't think of at the time of drafting that. And their courts usually, in democratic societies where the rule of law is important, they are very cautious about that. The Dutch court was explicit about that. They didn't want to step into the policy area. But if human rights mean something, you need to apply them also to new contexts. And in the 1990s, the European Court of Human Rights started its jurisprudence to develop into environmental context. And it has done so successfully, step by step. And I think this is, again, how courts should act in the democratic countries. And it has been tested, it has been confirmed, it has been legitimized. So what the Dutch court did was that it applied those two provisions using using the way the European Court of Human Rights had interpreted in other environmental cases, with considering risks, considering the future and all that, and then it applied it to climate change. But I think there is, and that we can probably find some cases where it's not fully clear. I am not so convinced about this case that has been brought to the European Court of Human Rights from the Portuguese use, because that refers to 30 states in a short application, without addressing exactly how each state has failed to comply with the European Convention, and without using domestic remedies. So, I mean, there are cases that are controversial, problematic, and I think it's important that the courts have this in mind. But you can still bring cases to court strategically, of course, even if you would not be successful. That could be a way also to show that, look, we need to improve the legislation, a bit like the German case did.
Yep, Great. And we should, of course, remember that there is nothing that sets the climate litigations apart in terms of how the judges are interpreting the laws, etc.
I agree. And I think what the climate change lawsuits show is that it is possible to transform by still within the idea of the rule of law. You don't need to have an enlightened despot or a quasi-democratic leader who shows with his or her right hand how to do. And I think that is the aim, to transform in a democratic way. And the court, I think the court cases show that it may work.
Yeah. Great. Thank you for that, Jonas. Now, I think our meeting host, Katie, has prepared to send you in the audience off to breakout rooms where you can discuss these matters. But before that, it's time for a poll. You can find it in the Pathable platform in the tab next to the chat. So if you click there, you will find one statement to consider, which is, do you agree that issues about climate and water justice are best resolved in courtrooms? And you have different answers to select from. So please make your choice there. And we have a second poll being, what is the best source of climate information to make fair decisions in court? And if you tell us what you think in one word, then we'll create a word cloud out of this. So what is the best source of climate information to make fair decisions in court? And I think Phil has also popped those questions in the chat. No, you'll find them in the poll. Good. Katie, how are we with the breakout groups? Are we ready to?
Yes, we're ready to move in. Do you want to show the questions on the screen before we go into breakout groups, or shall we just move in?
I think we have Phil maybe doing that. So we have two questions for you to discuss in the breakout rooms. And these are, what should be the role of courts and judges in the climate change transformation? And what can be achieved through climate litigation? So you have 15 minutes and you will be assigned randomly to groups with 5 people in each, I think. And you only have a short, limited time. So there's no room for introductions, full introductions of yourselves. Just say your name, your affiliation, and jump straight into your those questions. And when we reassemble, we'll invite a few of you to share reflections. So it's good if you have maybe assigned a volunteer for doing this. And we'll see you back here in 15 minutes.
Welcome back, everyone. Jenny and Jonas, you're back on.
Great. I hope you had really, really interesting discussions in your smaller groups. And I'm gonna ask one representative of each to maybe share something of the discussions you had. In the first group, I see Anna, Brendaline, Dwi, and Victoria. Would any one of you like to share? Just unmute yourself if you have a person from this group.
Yeah, hi, it's Victoria.
Hello, Victoria.
A bunch of engineers meeting because we're so excited of seeing what will come in the future. And of course, we hope a lot that it will become national legislation and it will be in force, and actually the number of cases will rise globally. Right. I mean, that's a hope. And we also saw that, and that's sort of what we can see for the future, is that modern companies, you can say, they always try to be ahead of legislation. So, I mean, that can also transform country by country.
Yeah, I think so too.
And then rules for companies that are not as modern. So the legislation will, of course, push all companies.
Yeah, and level the playing field, maybe.
Yeah. So that was sort of, yeah, and also, of course, we could see that corruption can hinder some of the
progress.
The progress, and also threats to individuals, of course. Yeah.
Absolutely. Human rights activists, for instance, and defenders. The threats are
a little bit of just a loose discussion. So thank you for bringing
Yeah, okay, thank you very much. Let's see, in another group, I think we have Benjamin, Fahir, and Naif. Would any of you like to come in and share, please?
Yeah, I can give an update. We discussed the role of the courts in, like better enforcing environmental legislation, but like we said earlier, it needs to be there in the first place. But Naif was talking about Saudi Arabia, where the enforcement is really lacking. And then also the issues around big polluters and oil and gas companies, for example, and using climate litigation to extract funds for climate damages, which could be used as compensation to most impacted communities. And also, from my perspective, the need to actually hold individuals directly to account, like CEOs of companies, because as long as it can be shafted onto like a legal entity and there's no personal risk, I think the chances of like very radical changes in like the behavior of how these companies operate is quite limited. So yeah, that needs to shift as well in terms of like personal liability, because it's people who are running these companies and making these decisions to carry on polluting. Yeah, I don't. Tahir, did you want to add anything else? Okay, I guess that's us done.
That's it. Thank you so much, Benjamin, and the rest of the group. Jonas, do you want to comment on this with personal liability and accountability and compensation funds?
Yes, let me comment on both these very briefly, because I thought Victoria made a point, and you also commented on something that I think is very important, that the legal frameworks can help to avoid free passengers, and they can be a means to avoid the tragedy of the commons. I mean, even the Paris, even if free riders, even if we can criticize the Paris Agreement at a global scale for being too soft on everything, it was fundamental that it was actually adopted, because I think it sent messages to investors, to companies, that this is the direction. So, as you say, provide a level playing field. But, and that links into the second one, to do so, in order for the legal framework actually to have that kind of, be that incitement or that push, it must be enforced. It must be shown that it's not only black letters on white background. And that's where I think the court can step in to hold states and hold companies responsible for failing to comply with these cases. The point about holding also the CEOs and others responsible, well, it is there. And in quite a number of countries, if you have cases where you can conclude that there are criminal liability is involved, then you could do so. It is quite difficult to show, unless we go to these cases where you say that companies have clearly violated the laws. Obviously, they have kept information secret or provided inaccuracy. In those cases, there may be a criminal case behind that it is in different way that they have cheated. So that I think is an important point. And in some cases, yes, I think it could add to point out the responsibility and to channel that. But I'm not sure yet if any of these high-profile cases have been about that. But for sure, I mean, we have a huge case that has been prepared for more than a decade in Sweden, but it hasn't yet taken off, about Lundin Oil in Sudan, which is really a serious criminal case. But it was not about climate change as such, but it was about working closely with local militias and so on, and thereby causing huge harm to the population. In those cases, for sure, you can include liability for individuals.
Good. It seems as if we're going towards more transparency and more accountability and ensuring better disclosure, both from companies and from governments at different levels down to the very local government maybe. And when it comes to industry, manufacturing, that there should be better traceability as part of these litigations possibly. Great, we have one more group. So I'm calling on Fatima, Josh, Mohammed. Please, do you have a representative of your group?
Yeah, I'll take the opportunity. Jenny, thank you very much. It was really a wonderful session.
Thank you.
And we were talking about, like you mentioned earlier, that there needs to be some sort of a national legislation so that the things, for example, the one who's going to destroy the climate or one who's making it unpleasantable, that needs to be accountable. There needs to be a mechanism of reward and punishment. For example, if somebody is going to deteriorate the water quality, either that's a firm, that is a company, or that is an industry, that needs to be a heavy fine on that. Because it's not the right thing, because those who are living in the lower riparian sites, what is their fault if they are living in the lower riparian? Yeah. They have a right to get the clean water. That was just one example. And we were discussing about the Ligari's case that he had filed against the government. So he was absolutely right. I totally agree with him that, for example, if there is something going bad, so the government should take care. Now in Pakistan, I know that there are some ministers who are working very closely in close coordination with some water groups. The people, like, for example, I myself, we used to treat them, we send them the feedbacks, and now they start taking action on that. So this is really something good. And climate justice is really a need of time. If we still keep our eyes closed and we are not taking care of it, believe me, we won't be survived.
No, that's absolutely true. Maybe we have others who would like to come in and comment. You can do so in the chat, or you can raise your Zoom hand and I can give you the floor.
Is there a minute for me to comment on Mohammed's last point, which I think is also important? And it's great that you were aware that you have been following this case and you may be more updated than I am about the Pakistani case. But I think you made also an important point about the usefulness of lawsuits, that they can push for new means, and they can show that even though this particular law works, that there need to be other measures taken. For instance, a fair insurance system for social insurers, or a fund where those who can pay for it, including corporations who caused climate change, are also paying for adaptation measures, for sufficient information system, or for building dikes or whatever there is in order to avoid harm. So I think your point is clear, that is another reason why these court cases can push for change to the better.
And while we wait to see if we have anyone else who would like to raise something, I'm also going to comment that, especially in international law, we have this situation where we can have binding rules. For instance, when it comes to human rights, we have commitments from nation states, UN member states, nation states that sign up and ratify binding treaties and conventions. But when it comes to companies, the private sector, there is only this expectation to respect the human rights. There is a responsibility. It is more and more clearly pronunciated, such as in the Shell case and probably others coming after. But we also have this problem that at the international level, we have no police force. So the enforcement, ensuring that there's adherence to the agreements, the treaties and the rules and the commitments, it is a true challenge. We have a hand here from, I think it's Josh. Please come on and use a video if you want to.
Hi. Yeah, so I mean, I wanted to talk about one other question sort of issue I've been thinking about, particularly related to resilience and climate justice, because a lot of the discussion from climate justice is about how the problem has been created, how the impact is disproportional, and how we can work to make sure that those people are protected in areas, mostly in developing countries and areas, but vulnerable groups, this will be a cyclical problem when we really think about resilience, right? Because to create those who have resilience are those with options. right? So there's resilience landscapes, and then you know that you can think about what the ecosystem, but sort of for personal security, personal water security and things, those with money and options, basically, to buy into places that will be more secure, you know, will continue to happen this cycle. And those without options will continue to live in the places that are not protected. Also, the places that will be protected first are those who get the information that they know that the risk is happening. They will make investments there where more financial assets are available to do that, where it looks like it's more effective because it's protecting more, and that will become cyclical as the values of those areas come. So, you know, there's this idea that we're just going to protect the vulnerable groups. This will actually keep happening in a cycle, because when you protect an area, it will become more valuable, and, you know, this will happen, and then gentrification. So I think this is something that might, I don't know if it becomes a justice or a lawsuit issue, but when we look at it, who gets protected, where it gets protected, and how you ensure that you don't just have a cycle of this happening, I think is a big area we need to look into. You know, and I raised the issue of insurance a bit earlier, because what will happen with insurance is not properly pricing the risk, because we can't assess the climate risks in the future well. If we get to the point where those revealed risks, you know, come into play, they will either not insure, or yes, perhaps they will not insure those things that become uninsurable, or certain places will make the investment so they could remain to be insured. And who will move into the places that are not insurable, not habitable? It'll be people with less money and less resources. So we sort of need a justice-oriented approach from the beginning to consider, how do we not just create sort of pockets of protection, you know, in our development. And I think that's skeptically a most likely scenario of how things will work, unless we try to stop that ahead of time.
Yeah. Thank you so much for those points, Josh. And from my perspective, I'm thinking that the human rights-based approach, it can only take us this far, because there are so many aspects of life and well-being that are not yet protected as an established human right. And I'm thinking about what Ashwin Vishwanath was talking about in our Monday session. He was giving examples of an early warning system for floods and extreme events in Kolkata in India. And I'm thinking that as part of the seminar series, we have also actually talked about that access to internet, access to stable internet connections, that's not a human right, but it's certainly, if you have it, it assists you and helps you in terms of early warnings. And if you do not have that, you will rely on other means to get information and move quickly, and even to actually shift to another place geographically, as you mentioned. So great, thanks for that. Do we have any other, anyone else who would like to come in and comment? We have a few more minutes, so.
So yeah, can I, in the meantime, see, so if someone indicates, please invite her or him, but just a few points. The last point you just said, that having access to Wi-Fi or internet is not the human right. I think this is a good example of how law can develop. Come back in 5 years or 10 years, and I'm most likely, given how important this is to have access to accurate information. Why in 2021 shouldn't it be actually a basic right to access? I mean, building this kind of infrastructure. So, I mean, it's a good example of how international or national human rights will develop. A short comment on Josh's point, I think, of course, is right. And it's important to link justice to resilience, and that it includes resilience for everyone. I think, though, that what we have seen in the last months is that those who thought that they were living in the resilient area, with that they had their assets in Germany and elsewhere, they can also be seriously affected. And if you live in the prosperous areas of outside Miami and Florida, or in the Netherlands, you can be much affected, even though you would think that you are on the good side of life, so to say. But that doesn't prevent that we need to take. It's clear that those who are worse off generally are also that are most at risk for climate change effects.
Yeah, indeed. Yeah, we used to think that we living in the Western world, the climate change is far away, is not gonna really affect us. But yeah, we have been reminded. We keep on being reminded. I think maybe Tarisai, I think you're unmuted. Is that because you would like to share something? No. Okay, we have a minute or so if there's anyone who wants to come in.
Can I come in briefly?
Yes, come on.
I'm from an organization called Water Witness, and I just wanted to flag a project we've been doing around this global evidence review on accountability mechanisms for water. And one of those areas of evidence we've been looking at is like public interest litigation and climate lawsuits. So I'll try and post links, but also, so there's like an archive there of like, you know, academic articles, organization reports on work which has been done on this issue, but also we're looking for more submissions if people know of good evidence and like write-ups around particular legal cases around water and accountability. That's really useful because we can add it to this online platform that we have, which is to kind of publicize this knowledge and make it available. So I'll post the details in the chat for people who are interested.
Fantastic, that's really great. And in the Pathable, under the tab Files, there are 2 documents already uploaded. One which Jonas referred to, and there is one more that may be of interest to those of you who want to read more about this. And there's plenty more online. Jonas told me that he has most of the relevant court cases in PDF form. So if you contact him, he can share as well. So great. Now I think it's time to look at the poll results. Kitty, do you have some poll results for us?
Yes, we do. Just one moment here while I bring it up. Here's the first question.
So this room thinks, neither agrees nor disagrees that issues about climate and water justice are best resolved in courtrooms. So exactly 50% of you or of us did not think this or the other. And then we have exactly the same amount of people saying somewhat agree, somewhat disagree, and strongly disagree. So we actually have more people leaning towards disagreeing with this. So issues about climate and water justice are maybe not best resolved in courtrooms. And indeed, there are very many other arenas for these questions that deal with governance and government, policymakers, democracy, human rights and equity, separation of powers, not the least. Jonas, do you have a quick reflection?
No, well, I think, well, in a way, it's a sound approach not to, again, over-romanticize the idea of going to court just because it looks good at films and drama. But I think it's true. I mean, and particularly if you think of this in the context of moving towards resilience. I mean, the courts are there. They are an important element, but they are not the key element or institution to provide that. But again, just to keep in mind that without them, implementation and enforcement of the laws will not be there, I think, and there are a lot of rights that may not be ensured to the same extent. But no, I think that it's interesting though. It's fairly split. I think there was no one who strongly agreed, which I think is, of course, an interesting point. There are those who strongly disagree. And again, it's a bit of skepticism. And there are other aspects that we haven't discussed. I mean, if you want to bring cases to court, the court must be not like Ritz Hotel, open to anyone who can pay. They have to be available. And bringing lawsuits are usually quite costly.
Yeah.
And in some countries, you run the risk of paying for the counterparty if you lose. So in that sense also, it must be available to anyone.
Absolutely. Good point. Thanks for bringing that up. Very important, especially when we see very many children and youth wanting to bring those court cases on, and they will depend on the funding coming from somewhere. Josh comments that the problem was the word best. Nothing is best to be resolved through court. It's necessary when there is a failure of justice. Better to do things right upstream first. Good. And very, very quickly now, Katie, the word cloud. Where are we? Right, IPCC is coming out big. Human data, climate, damages. Yeah, it's a little scattered picture here. I think one thing that you mentioned, Jonas, that the UN guiding principles for human rights and business is one such interesting. But
I think there is another very important point here. It's not in the biggest text, but the point about education and stories. I mean, science and scientist information data is fundamental, but education and daily knowledge is also extremely important to be able to bring these cases and to
indeed
to go that route. Yes.
Great. And with that, we have actually come to the end of this, but I want to thank everyone so much for this, and I'm going to hand over to Phil Graham for conclusions and wrapping up of this seminar series. But thank you again for everyone who have joined and shared your views and discussions today.
Okay, I'll just hop straight in, and thank you, Jenny and Jonas, for a very interesting session, and all of the participants. Information, governance, and justice for climate resilience. It's my role to try to summarize our deliberations on this topic during this seminar, and not just this session today, but the other sessions we had earlier in the week. As background, these discussions actually began a year ago. So we were to meet in Stockholm World Water Week 2020 to carry out this seminar. As many of you know, this was hastily replaced by a quite abbreviated World Water Week at home. We did have some discussions there, and then later in October, we followed up with a webinar discussion that had more of a focus on climate crisis and COVID-19, exactly. But now a year later, the discussion continues, and some might say that we're perhaps repeating ourselves. I would rather say that the discussion continues to mature and is perhaps even more poignant than it was a year ago. Increasing resilience requires better integration and interaction. Information, governance, and justice must overlap and must interact. So we have highlighted some real-life examples on technical solutions, governance and participation, human rights and justice, and through presentations and storytelling in session 1, through expert discussion in session 2, and now in this latest seminar session with more focus on climate justice, not only by listening to experts, but also in discussion with people like yourselves. So some of the things that we've discussed this week, I'm talking a bit quickly now because my time is running out, but 2020 will be remembered for COVID, that we all know. And then it was said that 2021 will be remembered for weather extremes, floods, wildfires, and drought. But will it really? As these extremes become more common, will it be only one year of many? With the right information, we can provide warning services for disaster situations, but this is not always enough. We also need the right understanding to react. If we take the recent cases in Europe, something did not work well with the recent floods in Germany, despite having good information. But in another example, over 2,000 lives were saved in Nigeria using the provisional fanfare flood warning system on the Niger River. We heard about that earlier this week. To build resilience, we also need the right information on the right scales. High resolution weather and climate data is not equitably available around the globe, so not everyone has access. Many countries are currently working on new indices. We heard about this yesterday. This has actually shown to improve inclusion in lesser developed countries. And the next wave of NDCs will also strive toward adaptation, not just mitigation. So the NDCs have a role to play in adaptation as well. We know that youth are the future, but they are also an imposing force in the present. With the different eyes, they have an increasing role to play. Will they, for instance, be the leaders for climate justice litigation? Indigenous peoples have their own knowledge about climate and the environment, and with a stronger connection to nature, they have more information to share. So in this session on climate justice, can we attain it through judicial means, or are they part of the solution, or will they detract focus from the problems? Well, I don't think we have consensus on that, and the poll maybe pushed it more toward the opposite side, but I think we can conclude that they have a positive role, as Jonas said earlier. The courts take these cases seriously, and they tend to raise awareness. And there have been some 800 lawsuits to date, and this will continue to rise. We have gone through more than a year of an invasive pandemic. It is not only invasive to our bodies, but also invasive to our lifestyles and how we meet. We have gained new insight into the importance of water from the heightened need for good hygiene. A similar parallel can be made on the importance of water for building climate resilience. We have recently received further confirmation from the IPCC that time is of the essence and that action is required to meet the challenges. This is neither new or unexpected. We will not, however, be able to halt climate change. The processes are underway, and the best we can do is stop fueling the global response. We will have to adapt. I repeat, we will have to adapt, regardless of whether it is 2 degrees, 3 degrees, or more. And increasing climate resilience is a must, but can we do this in a just way? People are frustrated, people are anxious. Yes, the pandemic has frightened us, but it has also taught us. Not only can we do things in different ways, we can also make life-saving decisions when needed and much quicker than previously imagined. We should also be able to build resilience in quicker ways. So in closing, I wish to thank all of you for participating, not only in this session, but in all 3 sessions of the seminar. And I want to thank all of our co-conveners as listed here. So the message to you in the audience in this virtual space, to all of us, is to act, to take action. Surely we can discuss this over endless hours, but think now in your own sphere of influence, what action can you take to increase climate resilience? Are you a technical person? Reach out to increase knowledge distribution, understanding, and participation, particularly understanding. Do you work with planning and organizing? Reach out to demand information that you need and to highlight how to achieve workable solutions. Do you work with issues of justice, human rights, judicial matters? Reach out to ensure that you are properly informed, that you inform on appropriate information and meaningful participation. All should work together to collectively develop capacity and common understanding of needs for equitable resilience building. Not only needs, but also the how. This you can do, and this is what we encourage you to do, what we encourage all of us to do. Just do it. To accommodate different time zones, this session will be repeated live tomorrow at 5 p.m. Stockholm time. So if you joined us late or want to recommend us to your friends, all can tune in again tomorrow. And if we're still recording, in closing, aside from our co-conveners, I will thank all of our presenters and particularly my co-conspirators from the World Water Scientific Program Committee, Jenny Grönvall and Katie Lackey. Thanks again. Continue engaging, not only during the rest of the week, but more importantly, moving forward.